Hi, I'm Walter Dellinger. I'm a professor at Duke University Law School on leave and a partner at the law firm of O'Melveny and Myers. I grew up in Charlotte, North Carolina, which was not a banking capital the way it is now, but really a small southern town. My father died when I was 11. My mother went to work as selling socks, ties, and underwear, and my older sister helped support the family. Went off to my state university at Chapel Hill and did okay there, but did some picketing of movie theaters and some broken hearts on my part and my broken heart. But I got my act together to hitchhike up to New Haven and talk my way into Yale Law School. So after Yale, I went to Mississippi, taught political and civil rights to the first integrated classes at Ole Miss, then clerked for Hugo Black, and then into law teaching at Duke. I'm not sure why I went to law school. I had thought very seriously about going to graduate school in history or political science, but I was not the sort that could have kept track of the note cards you need to write a dissertation. So I think I found my way to law school, and I thought Yale was the most sort of academic place, so I was sort of splitting the difference by going to law school there. The reason I got into Yale Law School, I think, is that people wrote them and said, look, he's got a very checkered undergraduate record, but he's going to be governor of North Carolina, so you ought to let him in. And letting me in Yale Law School actually ruined my political ambitions, because there I was, a Southern Catholic boy, and had gone to public schools. I got to Yale Law School, and I felt like I got in touch with my sort of inner Jewish intellectual, and that after that I'd always want to read some new book on the theory of law instead of going to rural Democratic Party barbecues and get started in politics. So Yale Law School kind of ruined me for politics in my case, because I got so attracted to the intellectual side of the law that I could never spend the time. And I in some ways I regret that, because I think doing the hard work of getting involved in politics and public life is actually admirable, and it's an easier way out to be an academic. Well, it's interesting. I wanted to do something for civil rights after law school, and going to Ole Miss, which had just 2 years earlier been integrated for the first time with the first African-American student, I thought teaching political and civil rights to a predominantly white class at Ole Miss, though by my second year we had more African-American students than any law school in the country, I think, except Howard. It was a very aggressive campaign by the dean until everybody got fired by the state legislature. But I thought that doing sort of missionary work among Southern white law students in a place like Mississippi was what I could contribute. I did a little bit of work helping out Marion White, now Edelman, who was with the NAACP Legal Defense Fund, but not much. Mainly I was teaching con law and civil rights. Well, when I'm asked what was my awareness of civil rights, it was omnipresent in my life. I mean, I didn't think much about the rightness or wrongness of segregation growing up until the Monday after my 13th birthday, when on that Monday the Supreme Court decided Brown versus the Board of Education. And I remember our classroom teacher announcing to the class that the decision had come down. The announcement was, I remember the exact words, "Children, the Supreme Court has spoken. Next year you will go to school with colored children." Well, we did. Our teacher was wrong, of course. And I graduated from high school, 5, 6 years later without any African-American student having been in a classroom. In fact, I had been to college, law school, and was teaching political and civil rights by the time there was the final integration of the rural and small town South in 1969. But from the moment the Supreme Court made its pronouncement in Brown, the issue of segregation and racial oppression was no longer a fact about the world. The court made it a normative question. I mean, and I think for many white Southerners, Brown made it an inescapable question that you had to confront. And you had to decide what you were going to do about it. And I know that there was a direct link between the court's pronouncement in Brown and my winding up on picket line in front of a segregated movie theater when I got to Chapel Hill for college. I went to American Legion Boys State, and they had an oratorical contest, and I spoke on prejudice and got booed. In fact, they had applause meters to pick the winner, and the applause meter indicated that I had won because I got the loudest noise, but it was actually all boos. That was when I was in the 11th grade, I guess. But so by that time, it was a commitment. I think my older sister was sort of who is now very much involved in Catholic left social work, was really my inspiration. I sort of got my values from her growing up. Well, I wanted to go to Yale because the law school was very much engaged in sort of very much active sorts of stuff. It enabled me to put together my interest in the intellectual side of things and some social activism. But that's really what led me to Ole Miss after law school. And I would have stayed 3 years, except I got the chance to clerk for Hugo Black in '68, '69. What is interesting to me is that in the South, growing up, in high school, in college, we all thought we wanted the South to be like the North. There was this mystique that the North was the promised land for African Americans, and that's what we wanted the South to be like. And it took a while to realize how much racial prejudice and discrimination there was in the North, and I think we're much more aware of that today. In some ways, the South has made an easier transition than a lot of the northern cities, where there's a sense of estrangement between the races. Well, I applied to Hugo Black when I was a third-year law student and did not get it. Each justice had 2 law clerks at that time, and I applied right when I was still in law school. And I applied a second time, my second year at Ole Miss. And I think Black had a real attachment to the South, and actually a real attachment to civil rights. Even a little bit of his categories hardened by the time he was 83, as he was when I clerked for him. But I think basically the fact that I was teaching political and civil rights at a Southern law school was something that made him think he wanted to set me on the right path. No, I wanted to apply to Hugo Black for many reasons. I had to leave the classroom in the 5th and 6th grades, public school classroom in North Carolina, when the Protestant Bible teacher came to teach the truths of the Protestant faith to our public school classroom. And the one Catholic in the class, me, and the one Jewish kid, my friend Victor Berg, we had to leave the room when the Protestant Bible teacher came in. So when I read Hugo Black's decision in the school prayer case, Engel against Vitale, I was in college at the time. I was wowed with what this Southern Baptist thought about keeping government out of religion, and that really drew me to him. That brand of Southern liberalism that Black represented made me think that was the justice for whom I wanted to clerk. I applied only to Justice Black. Yeah, I said, you're the person I want to clerk for, and the only person I want to clerk for. So that's probably was a foolish strategy, but it was a wonderful experience. Yes, I mean, it was. He was still a very powerful force at the age of 83. I mean, he would work the 2 law clerks, my colleague Steve Schulhofer, now a law professor, and he would have us out to his house after dinner, and he would want to work till midnight. We'd be slumping over the table, and he would want to get out and work on another opinion. He was really an elemental force of nature. I mean, it's very interesting. He was so critical as a leader of the New Deal. He was really very radical in his economics, a real Southern populist, and a real linchpin of the New Deal among the senators. So it was quite an experience. Well, what was interesting is that Justice Black would usually have 3 opinions, a majority opinion and 2 dissents out of each sitting of the court. And he would take the most important one himself to do the first draft. And the other clerk and I would do the first drafts of the less important assignments that we had. And that he was full of passion about the writing. I remember in Tinker versus Du Bois School District, kids that wore black armbands and were expelled from school when they were protesting the Vietnam War. I tried to persuade him that his First Amendment views should favor the students, his absolutism. But by that time, he no longer saw it that way. And when I tried to rewrite and soften his dissenting opinion, he was writing about lie-ins and bash-ins and smash-ins, and he was not comfortable with the emerging radicalisms of the late 60s. When I tried to tone down one of those opinions, he sent back a copy from his vacation in Florida, marked 3 a.m. on the draft, and put back in all of his most heated rhetoric and said that he wanted me to send this to the printer without change. So looking back on some of my memos to Justice Black, I am struck by how I actually seemed to think as I was writing these memos that I was going to change the views of someone who'd been on the Supreme Court for 30-something years. But I was unlikely to influence his views in any large way at all, which I now realize in retrospect. Now, he made it quite clear that only one of us was nominated by the president and confirmed by the Senate. It was very touching. My mother, it was the anniversary of his like 30th year on the court. And President Johnson had a dinner at the White House in his honor. And my wife said, your mother would love to do this. So she let me take my mother to the White House dinner. And she met Justice Black and was charmed by him, when she came by the chambers. And she noticed that there was no one there but one other law clerk and a secretary and the justice. So she said to me, she said, you know, he's very nice, but he's quite old. If anything happens to him, will you get promoted to be the justice? And I said, no, Mom, it doesn't work that way. I would not be succeeding him. I'm just the clerk here. Well, it was a very interesting court. I clerked the final year of the Warren court. It was actually Earl Warren's overtime year. He had resigned a year earlier, but Abe Fortas's nomination had failed as Chief Justice. So Warren stayed on another year. And the day I left, Justice Berger started as Chief Justice. So that it was a very liberal and active court at that point. So it was a very different feel than the court today. Justices Stewart, White, and Harlan were the, quote, conservative, unquote, justices who would be, I think, probably left of center on the current court. Well, it was still true then, and I was surprised at the extent to which the court operated as 9 separate law offices, with one very senior partner and 2 very junior associates and a secretary. And that the justices were not entirely comfortable approaching each other about changing their views. So it was often the case in every chambers that Justice Black would say, will you talk to Justice Stewart's law clerks and see if he might be persuaded to change this or that about the majority opinion. There was a lot of using the clerks as emissaries to other chambers to negotiate changes in opinions. Yeah, no, at least in those days, there was no preparation for being a Supreme Court law clerk. You walked in the door and the outgoing clerks just left you with a pile of work. We were only 2 law clerks per justice, and instead of 4 that the court now have. And the court decided 168 opinions the term I clerked, instead of something closer to 68 or 70. So we did far more cases, and in some ways far more slapdash. But the opinions were a lot shorter because nobody had time to write these lengthy law review articles that the court produces these days as opinions. I think he had become, I think there's a certain rigidity that sets in, at least to some people as they get older. There was a bit more rigidity about Black in '83 than I think there had been at earlier points in his career, but sometimes that rigidity was very beneficial. A year or so after I finished clerking for him, he got to write his great opinion in the Pentagon Papers case, which is, he got to almost his valedictory as a paean to the First Amendment and its role in keeping us out of foreign wars with foreign fevers and foreign shot and shell. It had almost a World War I flavor to it. But Justice Black was opposed to every war the U.S. ever fought except for World War II. He was vehemently opposed to the Vietnam War, for example. Early on, there was 68, 69, before much of the country had turned against the war. He thought World War I had been a mistake. And so he felt a particular passion about the Pentagon Papers and what they revealed about how the country was being misled. He was a great writer, and his advice to me was, I want you to write it so that your mother could understand it. Knowing that my mother was a high school graduate, he thought people should be able to understand Supreme Court opinions. I think one of the unfortunate aspects of having law clerks is that when justices, as they did for most of our history, had to write all of their own opinions, you got a much more direct sense of what they actually thought about the case. They had to personally explain the basis of the decision. Now opinions often read like elaborate rationales or justifications that have little to do with what actually is moving the decision. I'm not talking about illegitimate factors, but just justices have certain instincts about what would make the system workable, and the opinions that often read like complex law review articles don't seem to reflect the way that justices actually think about cases, even when they're making a conscientious effort to reach the right result. It doesn't necessarily translate in the way opinions are written. I do. I think that I think the court's opinions have become greatly hyper-technical. For example, you will see in opinions elaborate citation to prior cases. When you're at oral argument, you don't hear the justices talking very much about prior cases. They're talking much more about consequences of ruling one way or the other, or larger issues. They don't think about what other justices who are no longer with us wrote years ago. They're trying to decide the case now. The opinion comes out, it's all full of precedent and case citations, and I don't think that's what moves the court. In many ways, if you want to know what moves the court to decide cases the way they do, listen to oral argument, which is much more like the Supreme Court's id. Opinions are like the court's superego, written by the, often drafted heavily by the law clerks that don't always necessarily reflect, what's motivating the justices, much of which you can hear at oral argument. For example, when the Affordable Care Act was argued, a number of the questions asked by Justice Alito and Justice Scalia seemed to be reacting in a hostile way to the fact that they saw the act as a redistribution, which really had nothing between young and healthy people and older and sick people, which really had nothing to do with the issue about whether it was an appropriate exercise of the commerce power. And as the Solicitor General noted, Social Security Act was a redistribution. But you don't see any of that reflected in the opinions in the Affordable Care Act cases. You see it reflected in the oral argument. So if you want to understand the court, either in addition to or instead of reading the opinions, listen to the audio of the oral arguments, which you can click through to on SCOTUSblog. I don't know why the court has changed in terms of opinions, but I think 4 law clerks is probably too many. Yes, the term I clerked, we decided 168 cases by full opinion. Now, the court did not necessarily decide all those questions well. And mistakes were made in the opinions, and I'm sure having fewer cases and half the number of cases and twice as many law clerks means that fewer mistakes are made in the opinion writing process. But there was, I think when there were two law clerks, was much more a collective enterprise of the justice and the law clerks, perhaps, than it is today. I think the court could use justices with more experience in politics. If you take the court that existed the day the Brown decision came down in 1954, every single member of that court, every single member had played a prominent role in national public life before going on the court. Every single one. There were 3 former attorneys general, 3 former United States senators, the most influential 20th century governor of California, at least before Reagan, and Earl Warren, who had been a likely presidential nominee of his party. So senators, attorneys general, presidential candidates, that was the court. Now, that court needed some professionalism, and when Eisenhower named John Marshall Harlan, a distinguished New York attorney, that was a useful balance on that court. But now, no member of the court played a prominent role in public life before going on the court. None. The Warren Court, the Brown Court in 1954, not a single member had been a judge before going on the court. There was no prior judicial experience, none, on the whole court. Now, virtually every member of the court had been a judge, except for Solicitor General Kagan, had previously been a judge, and I think the court is missing some sense of how politics actually operates. I mean, to me, the big loss that came when Justice O'Connor left the court is not just that it lost an influential woman, but it lost the only member of the court who had held elected public office, who'd run for public office, who'd been part of a legislature, who'd been part of the horse trading that goes on in the legislature. And I think the current court treats Congress as if it were a federal district judge, doesn't have the kind of respect for the institution of politics. And I think the notion that a court should be made up of 9 appellate judges, many of whom had been professors in their prior lives, like Scalia and Ginsburg and Breyer, Kagan, good justices, but I think that's a very limited range of backgrounds compared with those who had served in the Senate or been governors of the state and or played prominent public roles like Thurgood Marshall played. And so presidents have a hard time finding the right political figure. I know that President Clinton wanted Mario Cuomo to be his first nominee to the Supreme Court, and Governor Cuomo wouldn't return his phone calls. I was in the White House at the time. But I think it's somehow hard to find the right person with political background. But the notion that people going on the Supreme Court needed to have been academic scholars and need to be able to recite what they know about 75 or 100 Supreme Court opinions to the Senate Judiciary Committee makes me think we're really getting on the wrong track in terms of the model. I think a mix is best. To have some academics. There's very little on the court in terms of people who have actually practiced law in the trenches. Both Justice Ginsburg and Chief Justice Roberts were appellate advocates. But only Justice Stevens was the last person who had a real great big law practice as he had and even then his law practice was in days when law practice was much more genteel. I mean, the court has to make decisions where there is no precedent. To be a lower court judge is to follow precedent, you've got a hierarchical court that you're responsive to. The system works best when lower court judges are fitting within the law as it exists. Questions come to the U.S. Supreme Court because there's not a ready answer in most cases. So there is more room for judgment. They're not umpires. They're not calling balls and strikes. They're exercising judgment at that level, which is why we call them judges and not umpires. But I think the biographies of the present court have led them to have an extraordinary contempt for Congress and for politics. Politics is not evil. A colleague of mine once said, politics is the way we govern ourselves collectively if we're not going to be a tyranny. And so I think the single greatest shift between the court on which I clerked and the present court is the degree to which the court respects the judgment of other branches of government. And the Warren Court is portrayed as being activist, but it was providing a criminal procedure code where no state legislature had even provided one. Individual police departments were making up their own laws. It dealt with a system of racial oppression in the South that was clearly contrary to the Civil War amendments. But it deferred to and respected the judgments of the national legislature. This court treats the national legislature with the back of its hand, and unless the national legislature jumps through certain hoops, it gets no respect from this court. I mean, to me, the most striking decision of the current court is Shelby County, where the court invalidated one of the key provisions of the Voting Rights Act and treating Congress as if it were a recalcitrant pupil for not updating the coverage formula, as if the court didn't understand that there were powerful reasons for sticking to the historic formula and not making fresh accusations about which jurisdictions are racist now and which are not. Just stick with the traditional formula for which states have to, get permission to make changes in their voting rights laws where there's been a history of discrimination. So that I think that is one case among many that stands for a lack of respect for the institutional role of Congress. Well, I think the background of this set of justices makes them less inclined to respect the work that Congress does and the hard work of politics. Well, to ask whether the court is a political institution, I don't think the court is a partisan institution. But I think the court, in making judgments about what a phrase like a law respecting the freedom of speech means, or what constitutes equal protection, or privileges and immunities, obviously judgments like that have to be infused with your sense, sharp or vague, about where justice lies, what constitutes equality, what is the freedom of expression, and to what does it apply, and what are its underlying purposes. It's simply not a matter of answering questions as if you're taking the LSAT, when the court is operating. Now, this is a very well-informed court. I mean, I think in terms of being an advocate before the court, there's probably never been a court that is sharper, more intense, better prepared, more probing in its questions of advocates than this court. I think not at a time in the court's history has there been a court that has been this smart in that sense. So that I think most people who argue before the court will tell you that it is almost impossible to get through an oral argument. When there's a weakness in your case, it's almost impossible to get through an argument before this court without one or more justices exploiting that weakness and questioning you about that weakness. Well, look, I think to have a different mix of justices would lead to some broader questions, and questions that really go to the heart of what the court's doing. When the court's deciding voting rights cases, a larger perspective about the historic role of Congress. And Congress being the central institution that the Civil War amendments Congress is the central institution that the Civil War amendments were intended to empower. Well, it's a very daunting experience arguing before the court. It's very unlike giving a speech, because you have to go where the justices want to go. And preparing for oral argument There can easily be 1,000 different relevant questions that might be asked in an oral argument. And you try to think of many of them as possible. You need someone to help you prepare who's a very good devil's advocate, who's really skeptical about your position. You don't want to be thinking of the hard questions and how to answer them for the first time when you're standing before the court. And the fact that this court is so much more active in asking questions than back when I was a law clerk, it's really astoundingly different. You can, in the course of a 30-minute argument, you can get 60, 70 questions. It's really an extraordinary number of questions. I think one of the most challenging experiences for me, and one that is probably rare, is to be getting ready to argue a case before the court and have the court announce its decision in a case that you had argued earlier in the term, right before you get up to argue. And in my case, it was pretty big. I was getting ready to argue the line item veto case, Raines versus Byrd, in 1997, and the court was announcing its decisions. This was right after Memorial Day. The case was being argued after the usual argument sessions were over because it was expedited. And the Chief Justice says, Mr. Justice Stevens has the opinion in 96-2702, William Jefferson Clinton versus Paula Corbin Jones. Well, there was a hush in the courtroom. And I had argued on behalf of the United States that any litigation against the sitting president should be postponed until the end of his term. And we did not expect that decision to come down until the last day of the term, but here it was, 4 weeks to go. They're announcing the decision. And Justice Stevens' opinion was organized around repudiating each of the arguments I'd made as acting Solicitor General, one after the other. And it was just brutal. And I'm sitting there, 12 feet away, and everyone is watching my reaction as he says, now the next argument made by the Solicitor General is even more frivolous than the other arguments. And I'm engaged in sort of denial and bargaining and the stages of grief. And I'm imagining that the Chief Justice Rehnquist must be dissenting from this, and is going to acknowledge wonderful things about my argument in his dissenting opinion, when lo and behold, Justice Stevens mercifully finishes his opinion and he says, nothing. And the Chief Justice looks at me and says, General Dellinger, you may proceed. And I'm thinking, with what? We haven't heard from the 4 dissenting justices yet. And my deputy, Seth Waxman, is pushing me out of my chair to the podium. And I realized that there is no dissenting opinion, that Clinton against Jones has come down 9-0, repudiating the position we had argued. And I have to stand up and start arguing the line item veto case at that moment. That was my hardest moment. And as soon as I got a question, as soon as I was interrupted by a question, as to whether we were challenging the timing or the nature of the senators and our argument that there was no standing, I got that first question and I said, Justice O'Connor, we object to both the who and the when of this litigation. And that was a very bad answer. Because any answer that begins Justice O'Connor, when the question was asked by Justice Ginsburg, is a terrible answer. Justice O'Connor says, that's Justice Ginsburg that answered the question, that asked you the question. So I am mortified that I have done this. But I said, I apologize to both of them, and I said, looking at Rehnquist, and I apologize to you, Chief Justice Souter. And at least I got a laugh and let me recollect my thoughts and think that this lawsuit is no longer my problem. My problem is arguing the line item veto case. And from that point on, I felt pretty good about that argument. But I think that was probably the toughest moment I had before the court. And it's hard, the way the court's calendar works, ever to have a very major case you've argued come down as you're getting ready to argue another major case. So I don't know anybody else that's had quite that experience. Well, that's what is the high watermark of my arguing before the court? I think arguing the physician-assisted suicide cases as amicus because we took a position that was in between the parties, where there was a constitutional right to fatal medication, lethal medication, on the one hand, and a notion that there was no liberty interest whatsoever in how your life ends that's good against the state on the other. And we argued an intermediate position that really Irv Gornstein, who was in the Solicitor General's office, really helped me develop. We argued an intermediate position, and Justice O'Connor questioned me very sharply about it, but it was a position that she undertook, that she wound up writing what was essentially the controlling opinion, saying that there really is a liberty interest, and the state has to have justification for imposing suffering on people at the end of the life, and that while the present laws forbidding lethal medication were justified, that the court would continue to monitor this. And I felt really good that we had offered the court the position that was, at least for a time, a resolution of that case. I think what I feel good about the physician-assisted suicide cases, Glucksberg against the state of Washington, Bacco against Quill from New York, is that it's the one time where I think we had an influence on the outcome of the case. That particularly arguing as a friend of the court, when the court, a majority of the justices adopted our position and got them out of a box. Well, it was very interesting because it is the first time that questioning a justice has asked me questions literally before I got to the podium. Justice O'Connor jumped on me, and it's a good lesson. She said, "Your position is different from the parties, and it is very, very, very different. And how do you justify that?" As if that was a hostile question. But what's interesting is it was a position to which she was obviously drawn. And she was probing and testing that position, and to seeing what my best answers were that she could use to defend the position that she actually agreed with. So sometimes hostile questions are friendly questions. No, I didn't. I didn't know going in. It was a very hard, the physician-assisted suicide cases was very hard to predict going in. I guess the other experience I had before the court that I feel good about, in addition to all the ones that I don't feel good about, but was the rebuttal in the Exxon Valdez argument. I argued for Exxon that we started out with a $5 billion punitive damage judgment, and it wound up at $500 million. And I had to make a decision on rebuttal whether to go for 2 times compensatory damages or 1 time equal to compensatory damages. And about $1 billion turned on which choice to argue. And that was kind of fun to try to take a guess about where the center of gravity might be on the court by counting up justices at the time. But that was a good experience. Well, there's almost no such thing as spending too much time preparing for a Supreme Court argument. I think probably my best Supreme Court argument was my very first argument when I was a professor at Duke, because I basically took a sabbatical to get ready for the argument. I wrote the critical part of the brief myself up late at night, reading the footnotes in cases, sitting on the library floor back in those days. I think there's no substitute for preparation. There's no substitute for having devil's advocates ask you the hard questions, of having someone who can help you think about which poison to select, when sometimes you have to either carve out exceptions to your argument or stay with a flat principle with no exceptions, and what trouble each of those paths gets you into as an advocate, and which is the best way, and how to think about the court itself needs an exit strategy in many cases. They want to know what's the best way out of a knotty legal problem, and sometimes each advocate is offering up, here's the best way out of this tangle. So you have to think in terms of what not just of what's right or wrong about your position, but what's an end game for the court that's going to be workable, going to be workable for lower courts, going to be workable for private actors in the private sector or for government officials or law enforcement. What's a workable solution to this problem that you're offering up to the court that makes sense? You know, it's an interesting question. Does oral argument matter? Not in very many cases, but in very many cases, nothing matters. That is, there's going to be a right answer that the justices are going to come to. They've got very good law clerks, so that it's not clear that advocacy plays much of a role in most cases at that level. I think the briefing is clearly more important than the oral argument. But justices have told me and told others and tell each other that the outcome in cases changes every term in some cases by what happens at oral argument. Sometimes, for example, you're asking the court to take a step and the court wants to know where it's going to lead. Where are they going to draw the lines? If they create a cause of action or recognize a cause of action for some kind of injury, is that going to, quote, open the floodgates, or is there going to be a principal line that can be drawn around the hardest cases? I mean, I think that's, I think every term there are a few cases where oral argument really does make a difference. I think it is easier to lose a case at oral argument than it is to win one. That is to say, when the advocate has no good answer to the question, but counsel, if we agree with you and accept your opinion, where does that lead and where can we cut off the extended consequences of a ruling in your favor? If you don't have a good answer to that, you can make the court very nervous, and that can produce more of a status quo outcome. Well, I think one of the things that's most effective about the Solicitor General's office is the tradition of multiple moot courts, and where the people that are mooting you are people who have themselves argued 15, 30, 50, 60 cases before the Supreme Court. So you have very experienced advocates who are very good at anticipating what kind of questions the justices are going to ask. There's almost no substitute for that. I mean, the hardest thing in private practice is carving out the amount of time that you need to really prepare as adequately as you would like to prepare. The best advice I got about oral argument came from Irv Gorenstein, who heads the Supreme Court Institute at Georgetown and was then in the Solicitor General's office. He said that my problem with oral arguments was that I wanted to advocate like a professor. I was used to having a captive audience for 50 minutes, and that would allow me to set up a series of premises and then to build on the premises to a conclusion, like a pyramid. So it's very lovely to watch and very academic, but the problem is with this court, they cut you off halfway up the pyramid and you're not getting to the conclusion. And then what you need to do is to turn that pyramid upside down. When you get a question, you need to go with the answer and then substantiate or support that answer as well as you can with however much time you're allowed. But you've got to turn it upside down. And after that advice, when I would write out sort of sample answers to questions, I'd often notice that what I would do is take and mark the last sentence of a one-paragraph answer and make it the first sentence, and sometimes reverse the order of all the sentences. You've got to get to the answer yes or no right off the bat, and then defend it as best you can instead of sort of wanting the court to go along with you as you lead them through a process from premise to conclusion. That's not going to work. And that's something I had to learn to make the transition from being a professor to being an advocate before this court. What do you do about it? I like this. I like to keep, I like to sort of type out answers on a computer so that I can play with them. And then, you know, you don't really look at it during the argument, but the more you play with it, the answer, the more you trim it down. I mean, a lot of oral advocacy before this court is about time management, about trying to compress answers down to the essential nugget, because you just don't have the time to engage in professorial exposition. the quicker you can get to the answer, the better. And the court has zero tolerance for not saying yes or no as the first word. You're always better off if yes or no is the first word out of your mouth. It's not always possible, but that's probably the best advice you can give someone. I think the greatest difference when you're arguing as Solicitor General is that the United States is such a repeat player, that it has such long-term institutional interest, that you don't necessarily want to win every case at all costs, because what you might argue in one case might be adverse to the government's interest in another case. Whereas in private practice, you've got a client, an individual or corporation or whatever, you've got a client that needs a result, and you're developing arguments as best you can as to why the client should prevail. When you're arguing for the United States, you often have conflicting interests within that, quote, client itself. The Bureau of Prisons, for example, and the Civil Rights Division might have different views on whether people should be able to sue for police brutality without overcoming certain hurdles. And the Solicitor General has to resolve those conflicting governmental interests. And that makes, I think, the role, being the greatest repeat player before the court, places additional constraints on the Solicitor General. You can't give away the future authority of the United States just because that helps you win a particular case. Well, the most important part of the Solicitor General's work may not be arguing before the court, but making decisions about what the position of the United States is going to be. The Solicitor General will hear from contending forces within the government and make the final decision, subject to being overruled by the President, make a final decision about what the position of the United States is going to be. And that's a very important, very time-consuming, and very difficult function. Then, of course, you have to present that to the court, and they get the last decision. When I headed the Office of Legal Counsel, which I did for 3 years before going to the Solicitor General's office, I didn't realize at the time how wonderful it was that I got to make the final decision. And I remember the transition that July 1, 1996, that weekend when I went from the Office of Legal Counsel down the hall to the Solicitor General's office to take over that office, how frustrating it was that I was going to have to persuade some justice, Justice Kennedy or someone, after I'd already decided what the right answer was. When you head the Office of Legal Counsel, and both Justice Scalia and Chief Justice Rehnquist, who had been head of the Office of Legal Counsel, told me that it was their favorite legal job, for the precise reason that you got to be the final decision maker and make decisions that were binding on the executive branch of the United States. And at the Solicitor General's office, you have to go and make arguments to the court. And I did find that a little frustrating. Also, when you're in the Office of Legal Counsel, you can tell the government to change what it's doing. No, you can't lawfully do X, but you can change it and do Y. Or you can take a proposed statute and say, this is going to be very hard to defend. We need to rewrite it like this. When you're Solicitor General, the law has already been written, the action has already been taken. You already know what your answer is. The answer is the United States should prevail, and you fill out the reasons. Whereas you get to actually make the decision about what the U.S. position is when you're in the Office of Legal Counsel. When a case is accepted by the court, or when the issue arises as to whether to urge the court to accept a case, and you're representing the United States as Solicitor General, you send out the Solicitor General writes to every department of the government that might have an interest, and every division within the Justice Department that might have an interest, and asks for written submissions as to what each component or governmental department thinks the government's position ought to be. And that sometimes results in a meeting in a large conference room with the Solicitor General, where you at least get to resolve the question of what the government's position is going to be. It is sometimes hard to persuade, to make people in government understand that if a cabinet department has a case before the Supreme Court, the secretary of that cabinet department is going to naturally think that the Solicitor General is his or her lawyer. And you often have to remind them or inform them that they are not your client. Your client is the United States. And you have an ongoing obligation to the United States and not merely the preferences of a particular administration that happens to be in power or a particular cabinet department, but the Solicitor General has a fiduciary obligation to the long-range interests of the United States. One of the things that a Solicitor General has to come to terms with is, when do you want to engage the President? And I would say in the 96, 97 term, about 3 times I thought I needed to meet with the President to get a decision at that level about what position we were going to take, and to lay out for the President what the competing considerations were and what my recommendation would be. Sometimes you will get, I remember, I won't identify whether it was me or some other SG, but I know at least one SG has gotten a call from someone in the White House insisting that a particular position be taken, an SG resisting that as taking that position, and being asked, do you accept the fact that, are you aware of the fact that the President gets to overrule your decision? To which the Solicitor General replied, yes, but I was not aware that I was speaking to the President. And the importance of that is, if it's important enough that the President wants to personally engage, that's fine, but you don't let everybody who just calls and says they're the White House try to, influence unduly what positions you're going to take because you do have an obligation to the court, and that works best for the long-term institutional interests of the United States. Oh yes, I have been, in my case, I took the initiative in bringing certain issues before the President. I thought it was a big mistake to try to defend the firing of a white teacher with that it was going to be bad for affirmative action because the school board had overreached, and that it was not, the government really could not and should not defend the action of, in this case, it was the Piscataway School Board. But that was such a controversial issue that I wanted to brief the President on why we were going to take the position we were going to take and why we thought it was right, and have him accept that position. I mean, there have been instances where I know of where the SG has taken one position, the Attorney General has disagreed. The two of them have decided to go to the President jointly and make their cases. The President disagreed with the Attorney General, but the court in turn disagreed with the President. And it was all a completely proper process. I mean, I think there are a few decisions that ought to be presidential level decisions because the executive power of the United States is vested in the President. They should be few, and the President should listen carefully to the Solicitor General and what he or she has to say about the best position, but ultimately the President can step into the shoes of any officer of the United States government. Well, I was in the White House actually relatively briefly. I did all the President's pro-choice executive orders, but as a professor at Duke, the weekend before he was being inaugurated in 1993, I spent 3 months in the White House while we were waiting to get an Attorney General confirmed, and then to decide whether I was going to be Solicitor General or head of the Office of Legal Counsel, depending on what the new Attorney General wanted to do about the mix of senior positions. It was actually very useful to spend 3 months in the White House. And ironically, by the time I got to the Solicitor General's office 3 years later, and even as head of the Office of Legal Counsel, having been in the White House helped ensure the independence of those offices. because people were very reluctant and never did overrule me. They knew I had the administration's best interests at heart. When I told them no, they knew it was because I thought the law just didn't allow us to tell them yes. And I never hesitated, I think, to tell the White House no, but also to tell them we thought hard about alternatives, if there were alternatives to be explored. I thought, for example, that when Ted Olson became Solicitor General, after he won the presidency for George W. Bush by his argument in Bush versus Gore, questions were raised about whether that would compromise the independence of the Solicitor General to have someone who had been the new president's personal lawyer in that role. I thought that exactly backwards, and that Ted Olson was exactly the right choice, and indeed that it was the best choice to protect the independent decision-making process of the Solicitor General's office, because no one was going to second-guess, nobody in the White House or elsewhere in government was going to second-guess Ted Olson's decisions as Solicitor General, because he had the confidence of the president. It worked out. So Ted would actually listen to, be persuaded by the seasoned arguments of veterans of the Solicitor General's office, and basically at almost every instance be able to tell any political folks in the administration to back off and have the confidence of the president. So I think it works in some ways almost backwards from what people think. An attorney general that had enormous independence was Griffin Bell, who had also been President Carter's personal lawyer, because no one in the political branches of the government could interfere with how Griffin Bell and his senior officials of the Justice Department were making their decisions. So I thought in that sense it was actually quite good that I had the experience in the White House before going to the Justice Department. I think it was very helpful to have credibility with inside the administration. In one instance, I was able to go to a cabinet officer and to say, I know it is the momentum in this administration, the policy momentum is to try to bring this issue to the Supreme Court. It would be a mistake. I'm not going to do it. It's a short-term political calculation that is leading to the pressure to take this issue to the Supreme Court. It is not in the long-range interest of the United States. And I didn't get overruled on that, I think, because I had a lot of credibility, you know, within the administration. And I think Ted Olson had that same kind of credibility in the George W. Bush administration. Having been in the White House, then in the Office of Legal Counsel, and then in the Solicitor General's office, I became quite convinced that a president should get his legal advice from the Justice Department and not within the White House. I think it is easier to make disinterested decisions and better decisions, even if you're just 8 blocks away in the Justice Department. That's a very long distance, because in the modern White House of any political party, the calculations are much more focused on the short term. I mean, every 20-minute news feed of CNN was the time perspective of people in the White House. I mean, there were people that looked all the way ahead to the evening news. Those people were called visionaries. But when you get out of the White House and 8 blocks away in the Justice Department, you're situated in an institution that has an ongoing identity, that has principles and procedures and policies where 90% of the people don't turn over with change in party administration, if you count all the assistant U.S. attorneys in the department. And there is sort of an institutional ballast there. There is an institutional stability, a sense of precedent and role that I think leads to making better legal decisions. The president needs advisors, and he needs legal advisors on his staff. But I would really argue, if any president asks me, there's one lawyer I really trust, where should that lawyer be in my administration? I would say you need to put her in the Office of Legal Counsel, number one. Your second most trusted lawyer should be the Solicitor General, and your third should be White House counsel. But that's because it's better to have the decisions made in the Justice Department that are going to affect your administration. You know, I do say it's, you know, I think, as I mentioned earlier, I think broader background experiences of the justices would be good. I think real experience in law practice is a deficiency. Too many professors on the court of both political parties, too many professors, many of whom I admire greatly, but I think a greater breadth of perspective. I would like to see more people who've served in the White House or in Congress, perhaps a former governor. All that would bring a different perspective to the court. You know, in some ways, the worst kind of politics is a politics that doesn't know it's a politics. And there's some sort of exaltation of, we're just deciding these issues mechanically, which some ways renders less transparent the grounds of decision. One of the reasons I admire Justice John Marshall Harlan II, I admired both the Harlans, but in particular I was thinking about the second Justice Harlan, because in cases involving the great claims of due process under the 14th Amendment, he really explained and talked about the considerations that he thought went into the decision, instead of acting as if it was all a mechanical matter and he was just adding it up on a calculator or an abacus and a result would come about. And I think that kind of candor about the process of decision making would be better. Well, I think the nomination process, there's a relationship between the nomination process and the kind of justices that we have on the court in terms of background, and I don't think it's altogether a good one. I think we have this model now of the professor, then judge, then justice, and therefore we have a model of a Supreme Court nomination process where we expect the nominee to be a law professor and to be able to answer 100 questions about standing and ripeness and what you think about this case and that line of cases, when, you know, if you took people who had great lives in the law, like the former U.S. senators or governors that used to be on the court, they wouldn't have, they're going to make up their decision about those matters when they get on the court. They wouldn't have any opinion about matters like that. Justice Black had been trying to save the country from the Great Depression when he went on the court. He wasn't into the nuances of technical doctrines. And I think I remember Senator Specter saying of one potential nominee, she's going to need a crash course in constitutional law. Her nomination was later withdrawn. But I thought, that's crazy. This shouldn't be an academic quiz on 100 cases. And it would be good to have a broader perspective on the court. Now, look, it's good to have some technically proficient justices on the court. It's not good to have 9. Because when you have 9 technically proficient justices, you're leaving out lots of other major experiences, like Sandra O'Connor's experience being the first woman who was a majority leader of the Arizona State Senate. That's a vital kind of background perspective. Or Thurgood Marshall's experience having led the civil rights legal movement. Well, you know, in terms of how conversant one has to be with legal technicalities to be a justice, Hugo Black, and I wouldn't go this far, Hugo Black argued that he did not think that you needed to be a lawyer to be a Supreme Court justice. And he indeed offered up publicly the example of Walter Lippmann, a great political columnist of his day, that he thought would be a good justice. And he said to me after his interview that he thought Earl Warren had been a great Chief Justice, and Earl Warren didn't know anything about law when he got on the court. He'd been governor of California for several terms. He'd been his party's vice presidential nominee. You know, he hadn't been writing, you know, law review articles and, or deciding cases as the Court of Appeals. There is a reason why no one on the court that decided Brown had any prior judicial experience. They were too important. You don't give up being the most important governor of California in a century in order to take a seat on the Ninth Circuit. You don't give up being the New Deal floor leader in the United States Senate to go on to the Fifth Circuit. So justices like Warren and Black that were there in '54 didn't have that. Now, Eisenhower correctly saw that there needed to be more balance on the court. That's why he named a state court judge like William Brennan. And that's why he named a highly skilled New York City practitioner like John Marshall Harlan. I think those were good additions to the courts. Potter Stewart had prior judicial experience. He changed that. But now that we're getting too close to the model of the professor, judge, justice exclusivity, and I think that's not necessarily the balance that the court needs. Well, it is said that cameras in the courtroom would change the dynamic, and I think that may not be all to the bad. That is to say, you would certainly not want to see lawyers showboating just because there are cameras there, but I don't think you would at the Supreme Court level. It would play very badly with any lawyer who had any sense. And I think sometimes the justices are unduly rude and abrupt and not comporting themselves with dignity, of making sarcastic remarks. And I think if cameras in the courtroom put some of the justices on a little better behavior, that quote, change in the dynamic of the court wouldn't be altogether a bad thing. Well, I think it would be useful for people to see the court at oral argument, and I think you gain a lot of understanding about what's going on at the court by watching oral argument. So yeah, I cannot think of any good reason. I mean, there's almost this notion that the justices are like demigods. Their office is literally a temple, modeled on a temple. I think there's an argument to be made that the building of that Supreme Court house in 1936-38 was a mistake. That, you know, you go to work in a temple every day, you think you must be a god or goddess, and that's not a good attitude. When the court met in the basement of Congress, I think, now it didn't stop them from bringing on the Civil War and the Dred Scott decision, so it's not entirely an answer to judicial hubris. But the old courtroom was beautiful. It was in the Capitol building, and now that they have a temple, I don't like the message it sends to the justices when they go to work every day in a temple. Well, you know, I think the Supreme Court, the journalists who cover the court are as good a group of journalists as you will ever see anywhere. I mean, it is an exceedingly difficult job to cover the complexity of oral argument, to get out those stories when massive decisions come down at the end of June. It's a journalistic corps that really respects one another, respects their fellow members of the press. I think generally the coverage is too judge-centric. That is, I've watched an advocate make an excellent argument and a justice be stupidly skeptical of it, and everybody writes it up that this was a failure on the part of the advocate rather than a failure on the part of the justices. There's always and of course they have the power, so that is, I see that as appropriate. But I do think that it would be good to have people be able to see more of the court's processes for themselves by having it televised. Now, I think popular understanding of the court, I don't want this to go to Tom Goldstein's head, but I have to say that Tom Goldstein is personally responsible for a significant enhancement of people's understanding of the Supreme Court and how it operates. I mean, SCOTUSblog has made the court much more accessible to people all out in the country, out in small towns who can get on SCOTUSblog.com, and much greater access to what goes on at the court than was ever before the case. Well, I'm not sure it's a great idea that the justices are out giving so many speeches and interviews. I may have played a role in getting this started. I interviewed Chief Justice Rehnquist at Duke, and then Justice O'Connor, Justice Ginsburg. I think I did the first public interview of Chief Justice Rehnquist. And I think now they proliferate, and every third day a justice is being interviewed or two justices are being interviewed. I think if the public wants to see more of the justices, they ought to see the oral arguments.